So number 4, exception. Tortuous interference with contractual relations. This happens when a third person interferes with a valid contract without a legal justification. So it's very clear, no? There's an existing contract and a third person enters into the picture even if he is not part of the contract. So the third person is already affected. 5th, contracts with stipulation por autrui. So stipulation por autrui is also for the benefit of a third party. Yeah. So what is this? This is what happens when a third party can claim benefits under the contract if the parties clearly and deliberately conferred a benefit to him and he accepted it. Okay, there's a third party who is benefited in a contract. Let's say, for example, seller and buyer agrees that 1/2 of the proceeds of the sale will go to the third person. So even if he is not part of the contract of sale, but the proceeds of the sale, 50% of the proceeds will go to the third person. So maybe to cover for his schooling, tuition fees. So that is an example of stipulation por autrui. So that's another exception to the relativity principle. But here, there are requisites that has to be complied. No? Stipulation por autrui has requisites. What are these requisites? So the first requisite, the parties must have clearly and deliberately conferred a favor upon a third person. So it's very clear in the contract, that proceeds of this sale will benefit a third person or will favor a third person. And the third person's name should be written in the contract. Second, the stipulation in favor of a third person should be a part of, but not the whole contract. So as I've stated in my example, only part of the sale, which is 50%. So not the whole contract. If the sale is, let's say, 10 million pesos, only 50% of that, and that is 5 million pesos, will go to the third person. So not the whole contract. Third requisite, that the favorable stipulation should not be conditioned or compensated by any kind of obligation whatsoever. So there is no obligation, no condition, no compensation whatsoever. And fourth requisite, neither of the contracting parties bears the legal representation or authorization of the third party. So there is no authorization or representation from the third party. So the third party must be there to communicate his acceptance. Here it's stated in the 5th requisite. See, the third person should be able to communicate his acceptance before revocation of the original parties. So meaning, in the signing of the contract, the third party should also acknowledge or communicate his acceptance. How much is he getting? In our example, is 5 million pesos. So he will also indicate, he should also be stated in the contract that he accepts such benefit. Okay, so these are the requisites. So do not forget, this may be asked in an enumeration number. Okay, there are different kinds of contracts. This time, They are classified, or yes, this classified according to perfection or formulation. So there are three kinds in this classification, namely consensual, real, and formal or solemn. So first, what is consensual? So consensual contracts are which are perfected by mere agreement of the parties. No, this is of the parties, not or. No? So perfected by mere agreement of the parties. So if the parties agree, there's already a contract. That's consensual. So example of that would be contract of carriage. As I've said, that you hailed a taxi cab and you agreed with the driver that he will take you to SM using the taxi meter. So that's consensual between you and the taxi driver. No? Also, another example is a contract of sale. If the buyer offers to the seller that he will buy his house, Mr. Seller, Mr. Person, are you selling this house? The owner said, no, I'm willing to pay 10 million pesos. And the seller says, oh, okay, I will sell you this property, provided you will give me cash. And the buyer said, oh, yes, I will give you cash. Is there a contract of sale? There's already, uh, yes, there's already a contract of sale, because contract of sale is consensual. But there are exceptions, no? So in that case, there's an exception that it should be in writing because it involves real property. But generally, a contract of sale is consensual. Number two example, under this classification is real contracts. So real contracts, like real obligations, are perfected by the delivery of the thing. No? So in obligations, there's also real obligation, which is to give. No? So here in contracts, real contracts are perfected by the delivery of the thing. So what are examples of this? Comodatum, pledge, or deposit. Okay. So I've already explained what is comodatum, di ba? The borrowing of a thing without any charge. I gave an example that I will lend you my book for the whole of semester, or my car for 1 year, a period of 1 year. I'm going to lend you my car for a period of 1 year. So that's comodatum. It cannot be perfected if I will not deliver the car to you. So the car must be delivered first to you in order that the contract of comodatum will be perfected. No? So perfection is a stage of a contract. Okay. Another is pledge. So pledge involves the giving of security of a loan, which is a personal object. So personal object is like a vehicle or motorcycle or jewelry. So if you are going to enter into a contract of loan and you go to a pawn shop, you bring your watch there or jewelry or a cell phone, you cannot enter into contract of pledge without depositing your or delivering your jewelry or your phone. Okay. Also in deposit, if you're going to enter into a mall, then you have to leave your things in order that the contract of deposit will be perfected. Okay. So there's delivery of the thing in order to perfect the contract. Another kind of contract in this classification is formal or solemn. So in this category, the contract is perfected by conformity to essential formalities or to some required form, no? As in formal, so it's a form. So there should be a written form. So a contract of donation cannot be perfected by oral or expressly given, no? So if the donor says, I will give you my car, is that a valid donation? It's not, because according to the law, donation is a formal contract. So it has to be in writing. So there should be a written document that that person is giving his car. Okay, and the donee, who is the beneficiary, accepts the car. So that's why it is formal. No? So these are the three kinds of contracts in this category. Now another category which is as to cause. By the way, cause is the third essential requisite of a contract. So cause could be onerous, gratuitous, or remunerative. So onerous, when there is a valuable consideration. Yeah. So I part my car to you for 1 million pesos, meaning I transfer my car to you for 1 million pesos. So that's a contract of sale. So that's onerous. A contract of sale, therefore, is onerous. No? Gratuitous is founded on liberality. What is liberality? Liberality is the same as generosity. No? So I'll give my car to you without any payment. So that is gratuitous. Okay. What kind of contract is that? Contract of donation. No? A while ago, onerous is contract of sale, while in gratuitous, it's contract of donation or cumudatum. No? I will lend my car to you. You know what I mean? Because I pity you traveling or commuting with the jeepney or taxi. Yeah, especially now, there's COVID-19. It's so dangerous to travel by public transport. So therefore, I'm going to lend you my car. So that is a gratuitous kind of contract. And what kind of contract is that? It is contract of cumudatum. No? Another kind of contract is remunerative. These are prestations. The prestation or the subject matter is given for service, no? Previously rendered, not as an obligation. So this is a contract of service, like a contract of employment, engagement with a lawyer. That's a service, no? Those kind of contracts are remunerative. Any other example? Contract to construct a house with an engineer. That is remunerative. Or contract to repaint a car. So you enter into, if you have a car and you want it repainted, so enter a contract with a painter, car painter, or an auto shop. So that is called a remunerative contract.